Are you all set with the tape? Okay, I'd like to call today's meeting of the Conservation Commission to order. The time is now 3:02. This meeting is being recorded. Would everyone stand, please?
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
We are here today with only one item on the agenda, and that being DI Trust Comprehensive Conservation Subdivision proposal to construct 135 single-family homes and 13,137 linear feet of associated roadway off of Forest Street, DEP file number SE 17-443. Okay, a brief history. This project was opened with us in June 21, I say June 24, 2021. That was 2.5 years ago. Since that time, changes in conservation membership have caused a lack of quorum to vote on this project. We have been in contact with our town council, DEP, and others to give us advice on where we are to continue and how we are to continue. There is a law out, a ruling, Mullen versus Planning Board, in which says that we need a quorum to be in attendance for all substantial meetings. New members can only miss, our old ones, only one meeting which has been viewed, read, and then signed for. That does not exist with this commission. There's been 2 of us only who have been on the commission for that period of time. Other members are new since then. So even if they have gone back and read everything, it appears as though that would not be covered by this Mullen versus the Planning Board. There's another law, Gamache versus Town of Acushnet, which says that the applicant must reapply in the case of getting a notice of, I should say, an order of conditions. So today we look to take action on how we can solve this problem, neither made by anyone directly or indirectly. It occurred. We can ask the applicant to withdraw and resubmit. We can ask the applicant to, or we can take no action and then ask the applicant to resubmit. Each of those actions would unfortunately be quite costly to the applicant. What town council has advised and is for the applicant to sign a letter to reopen the public hearing that was closed at our last meeting. Joshua, are you willing to do that?
So I've spoken with Attorney Costa on this issue and briefly with the town administrator in advance of this meeting, and my understanding of the current posture is slightly different. Yes. And I want to be very clear, we have agreed that we will work with the town on this issue, and I've spent a lot of time on the phone with Attorney Costa. So what the position that DI Trust has taken is that we are willing to work with the town on a continuance of today's meeting.
I'm sorry?
A continuance of today's meeting to the 8th or the 9th of next week, so that we would
be the 8th.
The 8th, which would be preferable, so that we would be within the 21-day decision period. At that meeting on the 8th, the expectation that DI Trust will roll with would be that this commission would vote to reopen the public hearing based for the reasons that you indicated, that they're due to, in part, changes in the commission, that you can't establish a quorum. So the intent would be to reopen the public hearing, to establish a quorum for purposes of us attending a public hearing to put on the evidence again. Same evidence, no new evidence, nothing additional, but we would make a presentation again. And it would be full, the engineers. And at that meeting on the 8th, presuming that we're all on the same page, which I think we are, we would agree to waive the 21-day decision period to dates certain that would identify a date for the public hearing and then a period of time that worked for this commission to then issue a decision, knowing that you would likely want to have a public hearing, close, have another meeting to deliberate as this was originally intended, and then issue an order of conditions. So we are not making the affirmative request, but we have agreed to that procedure so that this commission can establish a quorum, and that assuming that that procedure is what takes place, that we would then agree to provide a 21-day waiver under terms and conditions that would be agreed to by the attorneys, Matt Costa for the town and Ed Brennan for DI Trust. So, and Ed and Matt and I have spoken many, many times over the last 24 hours about this. Yeah.
Okay, all right,
So
so,
I don't want to speak for Attorney Costa, by the way, but I think Town Administrator
Yeah,
Mullins
yeah.
could confirm that what I just said is.
Yes, Tony Glass, he represented the town, he represented the town's position and Attorney Costa's position as well. Yes.
The only one difference was that if you turn in the waiver on Monday, that doesn't really give us enough time at all, because otherwise we need to issue a decision by Tuesday.
The intention would be that we would be providing the waiver on the
On the 8th.
8th in
Yes.
exchange for the procedure continuing under its current course of the public hearing being reopened. We're not, bluntly, we're not going to provide the waiver until we're all on the same page and agree the procedure works and everything's finalized and the terms. I mean, I got a draft waiver 45 minutes before I had to get in the car and leave. I just haven't had time to look at it with Ed Brennan.
This one right here?
Yes.
This 21 days?
Yes, and and we spoke with Attorney Costa. We're gonna have, some minor comments, because, for example, it doesn't have dates on it. And so, but the intention would be that you would receive a waiver from us prior to the expiration of the 21-day period, assuming that the plan that we have agreed to follow with Attorney Costa and Attorney Brennan works and procedurally addresses the issue of the quorum, which is what we've all worked very hard to try to address. I mean, don't get me wrong, we are trying to be collaborative here, and that's something that puts you guys in a position to be able to make a decision, because the alternative of no action just puts all of this in front of the DEP, and the local bylaw drops out completely. So, we're not looking to jam that down anyone.
Or Superior Court.
No, in this instance, if there's no action by the commission as a result of a lack of quorum, it goes to the DEP. The Conservation Commission would be a party, but the local bylaw drops out. We'd only be under the wetland.
But if the Mullins rule comes into play, it goes to Superior Court.
Respectfully, we've talked to Attorney Costa about this. The Mullins rule only means this commission can't act, and under the existing Massachusetts code, it actually goes to DEP only under the Mass Wetland, because it's not considered a denial.
Well, we can act under the local bylaw, even with Mullins rule. We can act under the Wetlands Protection Act, just not the local bylaw.
Then the appeal would still be to the DEP, and the local
Yeah,
bylaw
like we
still
do
wouldn't
have
apply.
town council involvement here. He has weighed in, and he has provided some really thoughtful advice. So yeah, I think it's in order.
okay.
Mr. Chairman, would it be okay if I restated my understanding of the order of operations, just to confirm
Certainly.
my understanding? So if we were to, just hypothetically, if we were to continue this hearing until Monday, by that Monday hearing, am I correct in assuming that we would be in receipt of the signed 21-day waiver and a request to continue, to reopen the public hearing at a date certain in February, at which point we would have all the information from the previous meetings represented as a final public hearing, essentially. And then at that point, we would close the public hearing and then issue a decision within 21 days? So I guess,
So that was. It was fairly correct, but had some, I would say that there's two components to that. One, we are not going to make the affirmative request. We will sort of consent to this procedure taking place. So it's up to the commission if they would like to follow
Makes
this.
sense, right?
We will agree to go along with it, and we won't object and not show up for these hearings. Like I will be there on the 8th, and I will be there at the public hearing. So that's one piece. The second is the 21-day waiver will sort of be an exchange. That if this commission determines that it wants to reopen the public hearing, which we will consent to, we won't object to that. We will attend all those meetings, and we will put on a presentation. Then in exchange, we will agree to provide an agreed upon 21-day waiver, the terms of which we need to nibble around the edges with the attorneys to confirm, but that part is true. And then, so that happens on the 8th, right? Then the idea would be public notice needs to go out, abutters need to be notified, and for a date certain of a public hearing, we would attend that public hearing along with the engineers, potentially the biologist, and for better or worse, you're gonna hear it all again. Everything, it would essentially incorporate by reference all prior submissions, all prior evidence, all prior presentations, and then we would put on another presentation. We wouldn't be providing new evidence. I don't think the expectation is that like anybody else would be putting on new evidence. It would be putting all the evidence that's already effectively in front of this commission in a way that all 5 of you are able to hear it, and you don't have a quorum issue that you currently have as a result of commissioners turning over since the NOI was originally applied for. Did I answer your question? Oh, and the other piece, I don't know that it would be a full 21 days between the close of the public hearing and when you would make a decision, but that's only because we haven't talked about it yet. I just don't want to say that, yes, we've agreed to it yet, but the idea would be that, yes, there'd be a period of time after the conclusion of the public hearing for deliberation and issuance of a decision.
So I had one more thing. In your final statement, in your first briefing, you used that we would be obligated to give you an order of conditions.
If you heard me say that and you want to agree to it, great, but I didn't know.
You used that term, grant you the order of conditions.
Well, and
yeah, I'm not-
conditions can be an approval or denial. We have to
Okay.
make a decision.
Yeah, we have
Okay.
not, this is, I mean, of course.
I just wanted to be sure that that wasn't,
No, of course, we would hope that with what I would personally and professionally tell you has been a lot of effort on our end to try to be collaborative, that we would get an affirmative order of conditions, but we are not conditioning our involvement in this
Thank you.
on you giving us a positive order of conditions.
Thank you. Thank you.
And then I guess, so just to clarify, my 2 remaining questions, would we need to speak with town council to know, are we able to reopen the public hearing without an affirmative request by the applicant to do so? I understand that DI Trust is willing to kind of consent to the reopening as it's part of this larger picture.
Yes, he has advised that we have an ability to do that,
Okay, so
yes.
that checks one box, and then my only other question is, if we do decide to reopen the public hearing, will we be in receipt of the 21-day waiver at the same meeting in which we vote to reopen the public hearing?
Yes, it would be an exchange. I will be here on the 8th.
Okay, so we would
And-
structure it as part of the
Yeah,
motion?
and you would have me standing here saying, if you vote to affirmatively reopen the public hearing on February whatever, and we're gonna need to figure calendars out.
Yeah.
We will agree to give you this executed 21-day waiver to make sure that, as Attorney Costa indicated, that he's got something from DI Trust showing that we've agreed to extend that 21 days.
Okay, gotcha, so as long as we maybe phrase the motion mindfully that we are,
I'll be standing right here and I'll tell you, if we're on the same, I would be surprised. I mean, I think at that page, we're either all swimming in the same direction, which I think we are, or we're
Yep.
not, which I don't
Yep.
think is gonna be the case.
And there was 2 other items too. The iteration of the plan that we are going to consider is not going to be the original one that was submitted. It's going to be the most recent plan that's been revised, okay?
We are not putting on any new evidence.
Right.
We are essentially
Everything.
resubmitting everything that you saw on the 19th, but you're gonna
just
get,
for legal reasons.
yeah, and you're gonna be getting the presentation. We were focused on basically 4 specific issues on the 19th, right? And those will be discussed again, but the idea is you're gonna be getting a full presentation. Unfortunately, it'll probably take a little bit of time.
Yep.
We'll try to be respectful, but we wanna make sure we're giving a full recitation.
And then the second thing was Beta still has a small bit of money left, and I think that would be a good time. If you are going to be there with your consultant, we would like Beta to be here at the same time to present the same thing.
that could be an issue.
For the commission.
Well, no, I would tell you that could be an issue because the public hearing is closed and I have no idea what Beta is gonna show up and say and do, and I'm hearing
Well,
that for the
Beta
first time.
would be presenting their existing letter. I mean, if you can present your information with your consultant, then we need our consultant to finish
At the public hearing?
at the
Just to be clear, Beta should be done. They were at the hearing on the 19th. We're just presenting evidence that Beta's already reviewed. It has already been presented to this commission. I'll be candid with you. If Beta's gonna show up at this next public hearing and treat this like it's still an open issue, that's the first I'm hearing of it. That's a
Well-
different conversation.
It's still going, we didn't have a quorum to listen to Beta at the other meetings,
All 5
Josh.
of these members were at the meeting on the 19th.
No,
where-
no, no, I'm talking about the other meetings that make the Mullins rule in effect. Mr. Phillips here, he was on at the beginning of this year, but he missed the 2 prior.
Understood, but Beta has subsequently issued at least 1, if not 2 additional peer review comments, all of which were incorporated in their entirety in the letter that we discussed on the 19th. Honestly, Lisa, that's news to me, and that takes me to a place where I don't have authority, because up until 30 seconds ago, I thought we were just resubmitting all the evidence they already had. We were making a
Right,
presentation.
but we also have to issue a decision, and Beta is part of our decision-making process.
Beta is a peer review engineer whose job concluded on the 19th. This is what we're trying to do, what DI Trust is trying to do is put this board in a position to address a procedural infirmity, not anything substantive. And I hope everyone here understands that we're working really hard to do that collaboratively. But having Beta come in and sort of basically reopen the substance of this is not something I've heard before.
We have all of Beta's written documents that we can, each member can review and take into consideration after they've made their pitch.
Yeah, we are going to be submitting all the information that Beta has reviewed. So there's no new information.
Right, but who is gonna present it? It needs to get presented.
Correct. We will present it, and it will conclude where we concluded on the 19th. But we are not submitting any new evidence, and therefore Beta should have
Beta
nothing.
wouldn't be submitting any new evidence either.
Right, and therefore, if no evidence is being submitted and they've had multiple bites at the apple on this, and this is about rectifying a procedural infirmity, I don't see why Beta would need to be there.
We can get all their written materials as they applied it to.
So,
Well, you know what? It's completely up to you guys.
so Beta was there on your presentation.
On the 19th, correct.
You were there for your presentation. Let's bring the same people back.
Yeah, honestly, Commissioner, I think if Beta is intending to attend that and essentially turn this into,
We wouldn't
another-
extend it out. It would just be one meeting, Josh. That's it.
I can say with a high degree of confidence that Beta is going to come in and say things that we either haven't heard before or things that we disagree with, and it's going to involve an additional back and forth, which is not what we're trying to do.
We aren't either.
Well,
I'm not.
But we closed out the public hearing on the 19th with Beta having an opportunity to present all of its information and evidence. And all we're attempting to do with the next public hearing is rectify a procedural infirmity by essentially incorporating by reference prior submissions and prior presentations and representing. But Beta is a peer review engineer who's already reviewed this project and then had the opportunity to comment and respond to what we submitted on the 19th. We are not presenting any new information. Beta, as a peer review engineer, would be reviewing new information. We will not have any
How
at the
would
next.
they be reviewing new information?
Lisa, I think that if we, as individuals.
I'm not prepared to draft the orders, and neither are you. I think Beta is more prepared to draft the orders, and that's what we had intended originally. Not that we would expect you to pay for that. The
No.
commission would have to pay for it.
Nothing would prevent Beta from reviewing whatever they need to review to assist this commission with drafting an order, but that's different than having them show up at a public hearing and engage in a back and forth when all we're trying to do is address a procedural infirmity.
Okay.
I think in order for you guys to make a full decision, though, you'd need both presentations again. I don't know, but that's up to you guys.
I think personally remembering all the data being so new,
Yeah,
that's a tough one to ask. It definitely gives the ball an upper hand to that side, being so new to this very extensive development.
yeah.
Well, for
As
what
long as they don't present any new information, are you willing to?
I mean, I think all we'd want them to do is read their letter again like they did at the last meeting, so that the guys that can vote now can actually vote based on what they learned.
So, we have not, there was no sitting down and meeting with Beta. All of their comments are in writing. So that letter has it all. And I think, again, I sort of understand, but not really. All their comments are in writing. You're gonna have everything from their review in front of you, because we are submitting it as part of at the reopened public hearing.
Who is going to read them in for the record?
We'll submit, I will confirm this. We will submit as part of our application.
Did you not hear me?
No, you said, who's gonna read them into the,
In for the record.
well, we can just have them available for the records, because everything is in writing.
Yeah, we will acknowledge, I mean, if necessary, we'll acknowledge, and we can even do this in writing, if it's helpful,
If-
the submissions that have been made by each party and the dates, which will include Beta's peer review comments. I mean, because again, just to be clear, we're reopening the public hearing. The public hearing will arguably already include all that information. We will affirm it, if that's helpful, and at the public hearing, that this is what we are responding to, this is what has been submitted. That's fine, because we are not putting on new evidence.
Okay, Lisa, if we have all of the Beta's comments in writing, we're gonna be able to respond and ask questions of their people as they make their
As long as
presentation.
you guys are comfortable, all the new
I
members,
mean,
everyone's comfortable.
I am comfortable,
know.
but I can't speak for everyone.
Like I say, we received that whole packet, excuse me, we went over it. They answered a lot of the questions, Beta answered the questions. You know what I'm saying? This is just to reopen the hearing and go from there.
That's my feeling of it too, because we have
We have all the information in writing. And
just
they
to have them,
addressed a
just to
lot of
have
it.
them read off what they said, I don't think it's necessary. All right, I want to go back, so you want us to in writing offer you or make, the request to on Monday to reopen the hearing?
You don't need to send us anything or put anything in writing. I would say if this commission determines that it would like to continue today's hearing to the 8th, at which point it would post, for purposes of voting to reopen the public hearing, we will not object to that. We will attend on the 8th, and we will agree if this is, if the public hearing, we will agree to the public hearing being reopened, and we will attend that public hearing and put on no new evidence, but all of the evidence that is currently before this commission, and also provide, assuming we're on that procedural track, a waiver of the 21 days.
Now, okay, Lisa,
Yeah.
in your opinion, can we do a vote now, or is that,
Yeah, you can do a vote, but I just think you
That's
guys,
not entirely accurate.
A vote to continue.
You can only vote to continue today because your current agenda does not permit you to take the procedural steps that you need to take to reopen the public hearing. That's why you need to have another meeting on the 8th.
right,
We
so
can
we
only
need to
continue to Monday, at which point the agenda for Monday can have the reopening.
to reopen? Okay, understood. Okay.
Right, and then I think we also should figure it out maybe now when the next meeting's gonna be.
Well, okay, so we're gonna go, we'll go the 8th. Then our normal January meeting, you're gonna have to notify all the abutters, correct?
So can I make a request when it comes to the public hearing? Because I literally was on the phone with everyone trying to work out schedules, driving over here. Right now, I can't get everyone here on the 15th.
Wait,
trying.
It's not the 15th,
No.
it's the 18th, January 18th?
Uh,
But the problem is, we would've needed we'd need to do it for the legal notice for next week.
talking about
the
February,
18th.
correct?
Yeah, I'm talking about February, because I don't think that the legal notice that needs to go out to notify, I mean, maybe it can, but I would probably say, given all the hurdles we're all jumping through, let's maybe make sure that there's time for the public to get their notifications and the letters to get
Well,
out.
so we're actually thinking of maybe our regular February meeting.
Right, so that's the one that we can't, I
February
can't get everyone there.
22nd.
We can't get everyone there on the 15th, it's the 20, we can't get everyone there on the 22nd. Right now, maybe the 15th, we're trying, we can't get, the 8th, it looks like we can. What I would suggest is we agree to continue to the meeting on the 8th at a time that works for this commission, and I will commit on the DI side to trying to get as many dates as possible to Lisa or the town administrator for this commission to meet on a public hearing. I just know that right now we can't do the 22nd. Unfortunately, I apologize. And the 15th is right now a soft no that I might be able to push into a yes. It's just people.
Okay, all right, so we'll just wait until Monday to take care of the timing.
Yeah, the intention would be by Monday to have,
Yeah.
we
We need to announce it Monday.
yeah,
at
you
the
have to
meeting.
provide a
Yeah.
date on, because the
Yeah.
public needs to know when the hearing is going to
So
occur.
with this, so we'll have to decide if it's gonna be a regular scheduled meeting or if it's gonna be a special meeting.
Well, if it's not gonna be February 22nd, which he's saying it can't be, it's gonna have to be a special meeting, so we're gonna add the 8th, January 8th, plus another regularly scheduled, special meeting.
Just to have it available. Just to have it available.
No, I mean, the 8th is, next week is another special meeting, today is a special meeting, and then we'll add another one.
Yep.
Okay,
And I apologize
that would
about the
be-
22nd.
That would be what, would probably be an evening, meeting?
We can figure it out, yeah, it doesn't
Yeah,
have to
okay.
be a Thursday.
All right.
There's someone in the audience, I don't know if we can.
Yeah, I don't,
Well, actually, I don't know if that's gonna,
is it, yeah, is it about?
It is
No,
about
this-
the meeting and the time.
Yeah.
Yes, it's just about this, if I may.
Yep,
you know, this here is very specific because
she
the,
wants to ask about the
This is
meeting.
Specifically about the meeting
Yeah.
and the time. Heidi.
it would be,
tomorrow-
next week would be Monday, the 8th at 3 PM, same time as
Okay,
today.
I had no less than 37 messages this past week from people saying, what's with the time? We work, 3 o'clock is kids' pickup
It's,
time.
it's to,
That's-
probably to help, mostly to help me out, because we're adding meetings to my part-time schedule here.
I totally understand, and I totally sympathize with that, but look around this room, and people are interested, people want to be able to be here, and that time is
Okay,
really
well,
a factor.
the next, I can understand because we thought we were gonna have, you know,
A
we can't do
decision.
what we thought we were gonna do, and that just
Yeah.
popped
We
up
were
out of
gonna
the
issue
blue.
a
I never
decision.
heard of the Mullins ruling before last week, never heard of it.
If we were
Just-
issuing a
just-
decision, none of the public could actually provide any input
Right,
at
just,
that
just to
point,
be
because we
clear,
closed-
is, once the public hearing is closed, we
Yeah.
can't accept feedback anymore. So if today had proceeded according to what it had initially been scheduled for, no one would be allowed to provide input anyway.
But, and I
So,
understand,
okay,
I understand
our
that, but
meeting that
it's
we're gonna
like
schedule-
plain telephone right now with the few people who show up just to inform people what happened, even if nothing happened, to inform them what happened.
Okay.
And that gets
They're
very
gonna get
confusing.
re-notified.
Okay, all right, I'm going to,
notifying everybody. That's part of this. Everybody's gonna get another letter of when exactly the meeting's.
It's the time of day that is the issue.
well, that's gonna sort of come out hopefully on Monday. Now, Monday, we're not gonna take any action except to reopen the meeting
To vote to reopen the
to
meeting.
vote to reopen the meeting,
Yeah.
and then to decide down the future. I truly suspect that all those future meetings will be in the evening. Okay, that will be determined on, well, I think determined on Monday.
We'll have to identify a date on Monday, the 8th.
Yeah, so whether it's a regularly scheduled meeting or it's a special meeting.
But it might not be 7 PM, it might be a little earlier. I don't know that it'll be 3 PM again.
Yeah, it
I mean,
depends on the commission's
yeah,
availability,
yeah.
so.
Are we, okay, so we need a motion then to have a meeting January 8th at 3 PM to,
It's to continue, right?
Yes, continue.
Continue.
to continue,
The public hearings.
to reopen the public hearing.
No, to continue today's meeting to January 8th. We don't have a hearing right now, this
Right.
isn't a hearing.
To discuss the procedure going forward.
Okay. So, okay.
Can I, so I'll just read what was from the email back and forth between Attorney Costa and us, if it's helpful at all. So, that you would move to continue the public meeting to the 8th at 3 o'clock with, notice that the commission on the 8th will consider reopening the public hearing
Yes, that's exactly.
to avoid any quorum issues.
I'd like to propose a motion that we reschedule the public hearing to Monday, the 8th at 3 PM for the purpose of discussing the reopening of the public hearing in order to rectify past quorum issues.
Okay, I would like to add one thing, the public hearing for Forest Hill Estates.
Yes, for, so moved.
So moved.
You have to do roll call.
Okay.
No, we have all members
Is
here.
there a second?
I'll second it.
Okay,
Aye.
Paul Reynolds, aye?
Yes.
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 I don't vote.
No, you don't vote, okay. And so that was unanimous to
yes.
continue this meeting till Monday to consider the reopening of the hearing for Forest Hill Estates. Okay. And,
Thank you.
wow.
Thank you.
All right, to those in the audience, I guess I have to apologize. This just came out of the blue and something that we have never dealt with. I've been on the commission now for, I think, 48 years, and it has never, ever, come to this. And so it was all new, and we've been involved with the town council, well, Lisa has been involved with DEP and so many others to try to get this right. Okay, I think we have
She's got
concluded our
one more
business for today.
question.
No, there's no, if she wants to talk later, I think, but this is, we concluded our business for today, and there's no open discussion on Forest Hill Estates. Is there a motion to conclude today's meeting?
Motion to adjourn.
Second.
All in favor?
Aye.